Here are 3 common mistakes that the workers in California who are seeking an accommodation to their disability often make. The first common mistake is requesting an accommodation to a disability and at the same time refusing to provide the employer with any information as to why they need that accommodation. Although it's true that you have all kinds of medical privacy and medical confidentiality rights, the law is clear that when you request an accommodation, your employer has the right to receive basic information about your symptoms and your limitations that would require that accommodation. And it is only logical, it only makes sense that, hey, if your employer is supposed to accommodate you, if they're supposed to modify your schedule, provide you with an ergonomic chair or keyboard, or provide any other type of accommodation, it would be in the interest of all the parties involved if they know what's wrong with you, because it will also help them provide you with the most effective accommodation. So, to come to the employer and say, I'm not going to tell you anything about my limitations, my pains, my difficulties, this is what I want and that's it. It's a mistake. This is not what the law says that the employer is entitled to. They're entitled to know why you're requesting an accommodation. They might not be entitled to know the name of your illness. They might not be entitled to the exact diagnosis, but they're certainly entitled to know what symptoms and what limitations require your accommodation. So let me give you an example. God forbid you may have been diagnosed with cancer or some other serious illness, and that causes you headaches, or that makes it harder for you maybe to bend over and lift things. Your employer may not be entitled to know that you actually have cancer or some other serious illness, but he's entitled to know about the limitations that that illness causes you that require you to have an accommodation. The second mistake that workers often make is misunderstanding the term reasonable accommodation. They think that reasonable means perfect or the best accommodation, when the law plainly says reasonable. This means that your employer does not have to provide the best accommodation that can possibly be available out there. And it also doesn't have to be the accommodation that you chose. It only has to be reasonable. For example, let's say you have a back problem or you have a carpal tunnel and your doctor prescribed to you that one possible accommodation is getting an ergonomic chair or ergonomic keyboard. You go online and you find the fanciest, the best ergonomic chair that costs $5,000 or a keyboard that costs $500. If your employer comes back and says, hey, we found a chair that's going to satisfy these ergonomic needs for $1,500 and we found a keyboard for $150, and that is reasonable, what they're offering you is reasonable, then they comply with the law and they generally are not doing anything illegal, at least with regard to these specific things. The third common mistake that workers who are in the process of trying to discuss their reasonable accommodations with the employer make is quitting in the middle of that discussion out of sheer frustration, and at the same time believing that they have a strong case. In many cases, maybe in most cases, strategically, that's a bad move. And that's for a simple reason. You do not have a wrongful termination case if you were not terminated. For example, you request one type of chair or one type of keyboard or one type of modification to your schedule. The employer comes back to you, they offer something else. You say, no, this doesn't work for me, how about this? You go back and forth a few times and all of a sudden you give up, you quit, and it's fine if that's your choice, if that's the best thing for you to do on a personal level, but this will make any potential disability discrimination case much weaker because you're the one who quit, you're the one who decided to give up and say, you know what, I don't want to talk about it anymore. In order to make a case for constructive discharge, which usually means objectively intolerable working conditions, you will have to show an exceptional degree of disregard on the part of your employer for the type of accommodations that you need. As long as you have a reasonable discussion where maybe the employer doesn't get exactly what you need, or they don't act as quickly, or they don't give you everything you want, as long as you have a reasonable discussion back and forth and you quit, it's going to make your case much weaker, and it's likely not going to be worth pursuing. So, why am I saying this? It might be a good idea, before you quit, to have a consultation with an experienced, reputable employment attorney who can look at your situation as a whole and determine together with you whether you should resign, or maybe you should wait, whether maybe you should think of other solutions, and whether this is the right time to resign for you personally and for strategic, for legal purposes. Thank you.